Great. Thank you to Dean Cairo for sending that message to us today. And now I'm going to hand off to the moderator for the first panel of the day, ALEI Legal Specialist Nicole Cook, and she can introduce the next panel.
Great. Thank you, Meg. Well, good afternoon, everyone. And I'd like to take the opportunity myself to welcome everyone to the first day of the Agricultural Law Education Initiative's 7th Annual Environmental and Agricultural Law Conference. Nicole Cook, I'm the Environmental and Agricultural Legal Faculty Specialist at the University of Maryland Eastern Shore, and I have the great pleasure of kicking off our conference with today's first session entitled Environmental Enforcement Actions, New Tools in the Litigation Toolbox. We are honored to have with us Betsy Nicholas, Executive Director for Waterkeepers Chesapeake, Holly Porter, Executive Director of the Delmarva Chicken Association, Bobby James, Senior Policy Analyst with Maryland's Department of the Environment. Our panelists are going to discuss 2 bills that were passed during the last General Assembly, the Citizen Intervention Bill and the Environmental Enforcement Reporting Act. And if you have questions for our panelists, and I hope that you do, please type your questions into the chat box, and after all of our panelists have presented, we will read and answer as many of your questions as we can. And Betsy is going to kick us off.
Are you not hearing me? Oops. Can you see my PowerPoint? No? Okay. Okay, I'm hoping y'all can see this because I'm not hearing anything. All right, so I'm Betsy Nicholas, Executive Director of Waterkeepers Chesapeake. I've got 25 years in legal and policy experience in government, nonprofit, and private sector. So I wanted to talk you through these bills a little bit because I've heard some concerns and maybe misunderstandings. They're pretty technically complex. Well, one of them's pretty technically complex and is usually kind of a nerdy lawyer issue. And that's citizen intervention under the Clean Water Act. So the Clean Water Act is a federal law, but is delegated down to state programs. Maryland is a state that administers the Federal Clean Water Act, and that's under the State Water Quality Control Act. So instead of going to the federal EPA to get a permit, you instead go to the state of Maryland. They have the full authority of the Federal Clean Water Act when issuing these permits. States can vary their procedures a little bit, but the federal law sets the floor and the minimum for certain things. One of the things that it sets a minimum for is citizen involvement and citizen intervention. And the reason that we looked for this change is because Maryland law was inconsistent with federal law. And it wasn't really the way that law was written. Unfortunately, sometimes courts interpret laws and functionally change their meaning. And that's what happened here. So intervention only occurs when you have a situation where the state has already brought a Clean Water Act enforcement action. Intervention cannot exist without that state action first. So when the state seeks to enforce a National Pollutant Discharge Elimination System permit violation, NPDES, then citizens who have been involved can potentially have the right to intervene, which means participate in that case as a party. Now, they don't have the authority of the government. There's no way to collect damages or add fines or anything else. Just the citizens can at that point talk about their perspective. You also must meet standing. There was a lot of confusion about this when we were working on the bill, that whether or not you can intervene is a step that comes after determining whether you have standing. So standing is showing that you have a legal interest in the case. So the standing required under this bill is the same that would be required under the Federal Clean Water Act. And that was because there is no state standing. So we couldn't just apply what the state would use. The state doesn't have citizen suit provisions. So the only way the Clean Water Act can be enforced in Maryland is directly by the state or in a federal action. There is no, way a citizen could actually sue under this law. We had support from the Attorney General's office, and once we talked through this bill with most of the opposition, they realized that this really wasn't a very significant change and was just bringing Maryland law consistent with what was required under the Federal Clean Water Act. Here's a little diagram of how this works in federal court on one side, versus state court with intervention. So under state law as it was, citizens couldn't intervene. But under federal law, they could have. So if a citizen group, community group, neighborhood association, whatever, wanted to take an enforcement action, that could be done. It could just only be done in federal court. Also, if in federal court, the state brought that action or the EPA did, community groups, people that can show standing could intervene. But what was happening in Maryland is that you couldn't. And that's, like I said, a violation of the delegation agreement that Maryland has with EPA to administer the Clean Water Act. So this just fixes that part. And again, standing must be met first. So I'll go on to the Reporting Act in a minute, but I want to just mention a few things that this cannot do. It cannot cause additional litigation. It's simply impossible because it doesn't give any right to bring a lawsuit. It only means that when a party is hurt by that pollution, they can become involved with the state's action and be able to tell the court how they're impacted. Part of the reason this is really important is because there might be different interests. For example, the state might seek to just collect penalties from a violator, but a community might ask for something like a restoration of a stream that had been damaged, or restoration of wetlands, or actions of that sort. So it gives them an opportunity to voice their specific needs when that community or person has been harmed by pollution. So that's a lot of the reason that we felt it was really important to get this fixed, but also it is required by the Federal Clean Water Act. The Enforcement Reporting Act, again, just brings Maryland in line with other states. Several years ago, the federal EPA required that records for permits, applications, et cetera, all become online documents. It really eases administrative burden and makes accessing the information much easier for the agency, for Public Information Act requests, and for other things. And that's all that's being done here. States like Florida, Alabama, Mississippi, Virginia, more than 40 other states have online reporting of enforcement acts with them already, because it really just eases administrative burden on the agencies. We've, again, heard some things that were misleading or incorrect about this bill. It will not release information about an alleged violation or complaint because those haven't yet been proven. The state hasn't investigated, the state hasn't taken action. Concerns, of course, they're about hurting a reputation with an alleged violation. So those are not being disclosed. Those are not going on websites. It does not require a new database. It uses the databases that MDE already put together for air and water, and it just has that information about enforcement actions posted on the website. It only posts finalized settlement agreements. Again, this is during the negotiation phase when things are going back and forth. There's no desire, it's not final, so we don't want to put that information out there and haven't asked the state to do that. So it's only a final agreement. And again, this doesn't expose anyone to additional enforcement or liability because the state has taken an action. This is just sharing that information so that parties can know. Oftentimes we get, as water keepers, we get complaints about pollution discharges or see funny colors in the water or bad odors, and we'll refer those over to the state. They investigate and take action. But a lot of times we never find out what happens, not just us as water keepers, but the community members around them. And this will solve that problem. It will let them know that the state investigated and issued a violation or required some remediation, or the state investigated and determined that there was no problem at all. But either way, it gives us what happened with that issue and a final determination. And this does not apply to the Maryland Department of Agriculture. This is just for enforcements by Maryland Department of the Environment and the Department of Natural Resources. So it does not go beyond those two agencies. You can feel free to contact me with questions. Here's my contact information, but I just wanted to address a couple of other things. I understand that that one of the other panelists is going to be talking about some litigation that happened 12 years ago. That litigation was under federal law, not state law. There has never been citizen suit or private action against a farm under Maryland state law. In fact, it's simply impossible to bring them. There is no provision for that type of enforcement. So I'm not really sure how that's relevant to the bills we're talking about today. But I just wanted to flag that that is not what we're talking about. That's not what these bills do. As you can tell by the content of the bills themselves and the fact that they don't relate to Maryland Department of Agriculture, this issue, what we were trying to fix, is much more likely to be things like the Patapsco wastewater treatment plant that you recently may have read about in the news, or the Back River facility that have been consistently discharging untreated wastewater into local waterways and causing a lot of problems. That was something that was reported to MDE, and MDE shared that information that they were under consent decree at that time. But if, or I guess more when, we have this reporting information up, we can just check online and see that there has been a consent decree, that MDE is taking action and monitoring the situation. So that's really the need for this disclosure, and why it's really helpful to community members to understand when they're being impacted by pollution, that the state has taken an action, that something has been done, that they're going to be able to see some relief in the future due to that action, and they won't have to go through an entire Public Information Act request process to find out that information, which most people are not comfortable doing. So that's what I wanted to share with you today, and I'm happy to stay around and can answer any questions.
Thank you, Betsy. I'm so sorry, I have to apologize for everybody. We will definitely be posting Betsy's slides. Betsy, I don't know if you understood that those weren't showing, but you did a fantastic job, and thank you so much.
I did not realize that, because you can't see the slideshow and
absolutely no
at the same time.
And it wouldn't be an online conference without a glitch here or there, right? So we got over that, and we're good to go for the rest of the conference. But next, please help us understand better. Holly Porter is going to present to us.
Sure. So I'm going to hope that everyone is seeing my slides. And as Betsy said, if we're not, it's tough for me to be able to tell that one way or the other, so I'll do the best that I can. So again, my name is Holly Porter. I'm the Executive Director of the Delmarva Chicken Association, and I do not have years of legal experience by any means, so I'm not speaking on behalf or as a lawyer whatsoever, but really I was asked today to sort of talk a little bit about agriculture's perspective when we see bills similar to these two bills, and the question of, that now possibly enables a little bit more into the litigation tools. So the perspective that we're sharing is really as from the chicken community. So I often like to start and say that this is our chicken community. These are the people, the growers, the farmers that are raising chickens. They're family farms. It's usually a husband and wife, or maybe a father and son. They may have one or two hired folks to help out in the houses. But it's really, these are family farms that are small businesses. So they're not large, big businesses out there. And they do have a lot of regulations that are still expected to pursue for environmental reasons. But again, they're small businesses. They're small family farms. So anytime we see bills that potentially have any impact on for legal purposes, we start to get a little nervous. And as Betsy mentioned, she's absolutely right. One of the points that we get nervous about is really because of a lawsuit that did occur 12 years ago, and it was a lawsuit that occurred to a family farmer, and it was due to a mistaken identity of a litter pile. The group that pursued the lawsuit was not in Maryland, was an out-of-state group. It required more than 3 years of litigation, millions of dollars in legal fees on both sides. And it really played to a lot of stress on the farm family, the farm community overall, but especially for this family and their children. And it's often led to years of mistrust. And that's, the exact reason when oftentimes we see bills and we see anything that may be expanding the opportunity for legal actions, that folks get concerned within the ag world. And again, we have not seen any citizen lawsuits against farms, but it's not to say it can't happen. So again, just briefly,
these folks, they didn't care whether it affected me or my kids, or we were just, I guess, collateral damage. Farming's in your blood. You do it because you love it. If you make enough money every year to pay your bills, you're doing great. I've been farming pretty much my whole life. I'm 39 now. I raise chickens, we farm. I also drive a school bus. Farming's a hard business to begin with when everything goes right, but when something goes wrong, it's hard to bounce back from that. I graduated high school in '92. I decided to build chicken houses. That was going to be my way to help out with the farm. My mom, I took her down to dialysis, and something happened, and she never came home. That same winter, Dad had a heart attack. Here you are, 18, 19, all your friends are out partying and having a good time. Right there, you're taking over the farm, taking over a business. You grow up overnight. Everything in Maryland is tied to agriculture, poultry, corn, soybeans, everything. You've got to have everything working together just to make ends meet. You don't have chickens, you can't pay the bills. These folks, they didn't.
So, I'll stop there. So again, that's for many in the agriculture and chicken community, that's one of the first things that we think about when we think about any bills that introduce additional opportunities for lawsuits. We also believe strongly that litigation really slows down progress. So right now, currently, there's another lawsuit that's out there that's pending with the Aspen Coastal Trust versus MDE on the CAFO permit. And there was a decision by the circuit court from Montgomery County that would require for air emissions to be regulated within this CAFO permit. And again, for those of us in the chicken community, it's concerning. It's concerning because of the potential amount of money that's going to be spent on lawsuits that may not be spent on practices that are put onto the ground. And that's, again, where we have concerns in the agricultural industry and some of those practices that we are already putting on the ground that help take care of what's in the lawsuit now are vegetative environmental buffers, something that we've been doing for a number of years. So again, just continue, what some of the concerns are. The specific to open enforcement or the open enforcement action bill. Again, we are very much in favor of transparency. We think it's absolutely important to be transparent, but there's also a lot of concerns within the ag industry of how that transparent information may be used. And just a couple of weeks ago, we saw that occurred in a report that was put out when a group had received information from the Freedom of Information Act, which again, any citizen can do, and took a lot of that information and made a lot of headlines that, unfortunately, as you read more into the report and as you better understand the information that was provided, you can start to see where there was quite a few discrepancies and misinformation that was put out. Unfortunately, all of that does is to really cause distraction within the agricultural community. And it again sort of builds some distrust out there when information like this is put out and, unfortunately doesn't show what is really happening on the ground with farmers. So, again, it's important, and I'm glad. I know early on in the bill, there was a lot of discussion about complaints being possibly put up on the website. And we had a lot of concern about that because, as was stated, complaints are just that. They are just complaints. They're not necessarily, there's not necessarily any enforcement actions to be had. They have to be investigated. And it's important because oftentimes we see quite a few where complaints tend to slow things down for progress. We also have concerns, with violations. Oftentimes, and as was noted in the recent report that came out, that oftentimes the violations within our chicken community are paperwork and record keeping violations. They're not violations that based off of resource concerns. Now, when there are resource concerns that are identified and issues that are impacting the environment, I think it's important, and I think everyone within agriculture would agree that it's important for enforcement. But oftentimes when information is put out, it is not quite clear what in violations may or may not be. And of course, compliance is the goal of everyone. Everyone wants to make sure that that anyone is in compliance. But oftentimes compliance takes time, and it's often a process. Requires money, so it's not a matter of record keeping. Compliance is actually probably easier. Produce the records that you need. If there are things that need to occur on the farm, they may take a little bit longer time. But unfortunately, every time that farm is looked at, it is considered out of compliance. And again, those are things that are a little bit more difficult to show in reporting aspects and may not be clear to the public when they have information. So finally, I would say that, again, where the agricultural community gets concerned, when information is out there and when complaints occur, they really impede progress forward. And we saw just that case past couple of years over in Cecil County, where a family farmer was trying to transition from dairy, which is unfortunately going on some bad times, trying to keep the family farm and wanted to transition in becoming a chicken farmer, organic chicken farmer. And as you can see, it was about a 3-year process before that farmer was able to finally be able to get chickens into those houses of which he was in the process of building and which he had loans on. And if you go and look at the comprehensive nutrient management plan that was in the permit that was put in originally versus what was put in and finally approved, there wasn't a huge amount of changes to it. But again, a lot of complaints, a lot of neighbor citizen complaints, concerns, folks who just didn't understand, caused the small businessman to wait at least 3+ years and really trying to get his dreams moving forward. So again, not specifically talking about the bills per se, but just in addressing the overall concerns that oftentimes when bills like these are introduced, they do cause concern in the ag industry as to, and especially in the chicken community, as to what are the unintended consequences. And unfortunately, cases like these have been some of the unintended consequences that often make us nervous in looking at bills like this. So I'll stop there and happy to answer any questions at the end of the panel.
Great. Thank you, Holly. Next, we have Bobby, and Bobby's also going to be showing us the new metadata viewer from the Maryland Department of the Environment, and we will post also the link to that for you in the chat.
Hi, everyone. Thanks, Holly, and thanks, Nicole, and thanks, Betsy. I'm going to do mine in a little bit different order. I'm going to talk about the Environmental Enforcement Reporting Act first. As Betsy clearly spoke about, the Department of the Environment has been tasked with putting certain documents on a public-facing website to make them available when they were previously only available under the PIA. So the result, we hope, is that there'll be less agency burden responding to PIAs, as well as just sort of give the general public access to those documents. So what I'm going to talk about is what MDE has been doing or has done and has been doing to comply with the law. And then I'm going to do a brief demonstration of where it's currently located. First, MDE did build the database off of an existing platform that was used for the lead poison prevention program. Second, MDE developed a checklist that went out to all the programs so that they could determine which programs were going to be involved, because only programs that currently track through the MDE's existing database, the environmental tracking system, fall within the scope of the law. And then they also, MDE had to figure out which programs actually have the kind of documents that are required to be posted under the law. Finally, there's an analysis that's performed on those documents, data sets, to ensure that there's nothing being posted that needs a confidentiality review, and to ensure that no confidential information is posted on the website. So, for example, you're looking at issued permits, inspection reports, and final consent decrees and settlement agreements. Currently, the Water and Science Administration is the only program within MDE that's required to have the public-facing website. The other programs come online in, I guess, June of 2022. So the final version is going to look a little different than what I'm going to show you both. I'm going to show you what's currently there and how to get there, and then I'm going to show you just a view of what it's going to look like. So without further ado, and cross your fingers. So here's MDE's homepage. If any of you've ever seen it, you're familiar with it. So to get to the current database for water, you just click on water. And then you go over here to the left-hand side and click on compliance. Here's where it gets a little tricky. You can read about the compliance program if you want, but if you're just looking to find information, you can see it highlighted in yellow. Up-to-date information can be found here. And as you can see, here is a clickable link. You just click on that. So as I mentioned, that this is built on a database that already exists for the lead poison prevention program, which is the part that needs registered users because only certain people are allowed access to that. So you would just scroll down past that part where there's information about registering, and you can see the 3 different administrations. So for water, let's say you're interested in finding a compliance inspection report. You just click on WSA compliance inspections, and that'll bring the database up in a minute. There you go. So let's say, you sort of know the name of where you think there's an issue going on. You just type in the site name and you'll get a list of things related to that site. Now, if there's none of these rows are clickable, so what you're looking for is a document. So if you go to the far left-hand side, you can see the PDF icon, and you want to click on that. And there you get an inspection report that's current for the city of Hagerstown. Now, let's say you are interested in an enforcement action and to see what happened. Click on WSA enforcement actions. And say you know the name of the facility. Then you look for the icon on the far left. Click on that. And here you get the final version of the consent decree that was signed between MDE and the defendant. Just go all the way to the bottom. You can see it was signed by, okay, maybe not. All right, well, you get the idea. So that's what the current database looks like, and that's how to get to it and sort of navigate through it. When MDE's finished, the open portal is going to look like this. Okay, maybe it's not going to look like that. Hang on. Sorry. There we go. So that's what the new open portal is going to look like. It's very similar. So again, if you wanted to find an enforcement action, just click on enforcement action. And just the search is a little bit different. So say you only know the street address. That in there. Okay. All right, I'll go back to the. Sorry, folks. When I was practicing it earlier. Here we go. So here's P&J Contracting, 4300 Shannon Drive, in Baltimore, and you just click on the document. Brings this screen up. And then you click on the PDF icon. And there's the document again. So that's just a quick overview. Of how MDE sort of is trying to comply with, or has complied with, the Enforcement Reporting Act. With respect to the Citizen Intervention Bill, Betsy laid it out very well in terms of what it does. It still requires a citizen group or citizens to have standing in order to participate in the lawsuit. Because it's only been effective in effect since October 1, MDE hasn't had a lot of experience with it, although we have a couple cases or matters in the pipeline where citizens could benefit from intervention, and MDE is currently negotiating with those parties. One way that the act will benefit the citizens of Maryland is if there is a federal citizen lawsuit filed, but then MDE takes an action that would block that citizen suit, that same citizen group can then participate in the state action with MDE as a party, as an intervener, to get, as Betsy explained, make sure their interests are covered. Although that's a great benefit, the benefit is limited because a majority of MDE enforcement actions are taken through the administrative process. It goes to the Office of Administrative Hearings. In fact, just reading the annual Environmental and Compliance Report, only 5 Water and Science Administration enforcement actions were filed in circuit court, or less than 5, compared to the approximately 800 enforcement actions initiated by MDE in 2019. So that's where most actions are settled without having to file in circuit court or taken to the administrative, to the Office of Administrative Hearings. So in that regard, that benefit to the citizens group of this new law is very limited to state enforcement actions taken by MDE that are filed in circuit court. That's about all I have. So I'm looking forward to any questions that anyone might have. And thank you very much for your attention.
Thank you. Thank you so much, Betsy, Holly, and Bobby, for all of that great information. And I know that there's chats going on behind in the green room, so to speak, and there's chats happening elsewhere. And it's a lot to follow. And I think that we may have some additional resources available for folks who still have some questions and want some more discussion about this. As always, we tend to run out of time on important and complicated issues that we bring to the conference every year. I'm going to try to see if I can round up audience questions while we do have some time here. And I do have to, and if I miss something, please help me and point out what I'm missing. And we did post the link for the webpage. I'm actually not seeing, I hope I'm not missing any questions. While I'm continuing to look, again, one of the discussions that we were having was some further points of clarification on whether there was an expansion of the standing in the state of Maryland under this law. And Meg, can you bring, I think Betsy, you wanted to either discuss, and maybe also you have something to share. I just wasn't quite clear. Could we do that?
Sure. I can share it after. I'm sure if I figure I'm already having computer problems here, if I try and grab it for you right now, it would probably cause chaos. But yes, this was actually discussed a lot in the committee hearings. I mean, this is really boring inside procedure on legal stuff to figure out how the path goes. But it is, obviously important to people to know that the intent of this was just to be able to participate when the state's bringing those enforcement actions so the citizen can get a voice, know what's going on. As Bobby pointed out, and thank you, I forgot to mention that, this doesn't apply to administrative proceedings. So there's a rare grouping of cases where this is going to apply. But it's usually those big actions like Baltimore, consent decree for the combined sewer overflows. Those are the sorts of things where you're going to have a lot of different viewpoints about what the timeline, what the resources and remediation should be. Should it be green infrastructure? Should it be tunnels? Things like that. And that's where you really want to make sure that citizen voices can be in there, the affected neighborhood and those communities. But in terms of the standing, this all came up because of a court misinterpretation of the Maryland law. So Maryland was intending to give citizens rights to intervene in enforcement actions. The court just kind of got it wrong. That happens sometimes. And instead made it what they call permissive intervention. But the court found that anyone who thought that the environment was really their interest had the same interest, meaning citizens, neighborhood groups, anybody else, hunters, boaters, had the same interest as the state. And that meant they couldn't intervene. Whereas the Clean Water Act requires it for a state delegated program like Maryland that actually issues those permits, that they allow for intervention as a right. That if you've been involved in the proceeding and if you have standing, that you can intervene. So that was the same before. You still had, it didn't touch anything in standing. That just remained clear. The only reason we actually put it in the law when working on it was because people were afraid that otherwise you didn't have to meet standing, but I'm not sure. It may have actually added confusion, but it was an attempt to make it easier, for people to understand. So it's all written in the same place that you must meet standing before you can even be considered for intervention. And I have a fact sheet on that and a frequently asked questions that kind of runs through some examples that I will send to Nicole and she can include with my slides. There was a little diagram on there too that would have helped. Sorry, that didn't work.
I'm sorry too, my apologies as well, but thank you. Thank you very much. Yeah. Okay. I don't see any other questions. I hope I'm not missing anything. I'm seeing thank yous. I guess, okay. There's a question, Holly, requesting some affirmation from industry. When you spoke of the industry supporting transparency, and the question is, would industry agree to provide information about how much litter amendment or feed additive individual farms use to control ammonia emissions? And I'm guessing that's a question you've had before.
Sure. So, yeah, I don't know necessarily, wasn't prepared to answer that per se, but I do know that if you tune in, let's see, that would be Friday, to a STAC work group that we're involved in. There's a lot of discussions about litter amendments and some data gaps that might be missing in that. So that's with the Chesapeake Bay Program STAC work group, ammonia. I'm probably getting the title wrong, and that information.
Great. And we have time if you'd like to type something in the chat box, Holly, to let everybody know about that. That'd be great. I'll give folks just one more minute to see if we have some other questions that they want to type in. And I don't know, Bobby, if you wanted to jump in with any last minute thoughts or comments?
Well, yeah, I think I would agree with Betsy, maybe for the first time, that House Bill 76 does clarify, the point of it was to clarify any mistaken thoughts that the state has that Maryland is not complying with its Clean Water Act delegated authority. So House Bill 76 definitely clears that up so that, there's no question there anymore.
Betsy, their question just came in to ask you if you can give a specific example of how a citizen can now intervene in a court case based on the new law.
Yes. So I'm going to use a hypothetical that actually wouldn't work this way because MDE has already taken an enforcement action. But let's just say, we're going to go back in time a tiny bit, that the Patapsco wastewater treatment plant that has just had all of these overflows, if you read about it in the Bay Journal, and has caused pretty significant violations of their permits, and what they're releasing there is untreated sewage, right? So it's not not anything we really want in our streams and communities and downstream. So actually our partner over with Blue Water Baltimore was the one investigating this and did the downstream monitoring, reported it to MDE. So at the time, if MDE then moved forward with the enforcement action, which they may do on top of the consent decree, we're not sure, then Baltimore Harbor Waterkeeper could show their interest, or Blue Water Baltimore could show their interest in that case, which is the standing, and then would be able to participate along with MDE to make sure, one, it provides additional resources to the state when doing this, but it also provides that community and neighborhood perspective, people who live right around there. So that would be the type of example. Most things, the administrative actions, fines, penalties, and certainly anything like paperwork issues, those never get to the, to the point of being a court action where anyone could intervene.
Thank you. Okay, one more minute. We've got time for folks to type in some other questions. And while they're doing that, I'm going to be entering the link that Holly sent. Let me get that up here. Okay. We do have a new question. Can someone intervene at the time an administrative action is appealed for judicial review in the circuit court, or is it too late then?
Yeah, great question. Actually, we talked about that a lot in the hearings, and we wanted to clarify that an appeal does not give you the opportunity to change that. It's just in those in-court enforcement actions. If it started out as an administrative action, it remains an administrative action, and so that would not trigger the right to intervene.
Mm-hmm. Great. Here's the link from Holly. Any other questions? We have time for more questions. They're good questions. Yep. Okay, I think we've covered a good amount of information. Thank you so much, everybody. I'm not seeing any other questions right now. Okay. Well, thank you again. Thank you so much to all of our panelists. And we truly appreciate all of your time, as always, in supporting us and being part of this conference. And thank you to everyone who joined us for this session. And stay tuned now for the next session, which is using legal education to increase equitable participation in NRCS conservation programs. And that's going to start right at 2 o'clock. So thank you so much.
Thanks.